are on the record in the Norcutt matter, case number D16537-499.
Okay, thank you, counsel. Your appearances and your bill numbers.
Fred, you want to go first since you represent a party?
Yeah, I did. I had myself on mute, so I fixed that. Thanks. Fred Page, bar number 6080, on behalf of Goldie Norcutt, who is participating via Blue Jeans link.
Thank you.
Shelley Cooley, bar number 8992, court-appointed guardian ad litem for the child.
Okay, this matter was settled from yesterday because Mr. Page was at a bank breaking into a safety deposit box with a court order. So thank you, everybody, for accommodating. And I wanted to tell everybody what was going on with your trial. You are one of a list of trials that I have to finish before I retire at the end of the year. There have been some recent news about spiking of cases and actually hitting the courthouse. There was an article in the RJ last Saturday about 5 deputy marshals getting COVID, testing positive for COVID. There was a email from the chief judge saying there have been at least 14 reported cases of COVID positive people, and once they find that they're positive, they're supposed to quarantine and stay out of the court buildings. But there are also rumors flying around that people might know that they're COVID positive and they're literally still coming to work and not disclosing it. Can you imagine that? But I'm not going to put past people to actually do that. We do work in a public building. Yes, if you're COVID positive, you're an employee of the courthouse, you're supposed to notify the employer, notify the health district, stop going to the courthouse until you test negative. But apparently some people, I don't know if they've been caught, but they're doing that for whatever reasons. Okay. I mean, it shouldn't be a problem because they can get sick leave and do all that, but you're endangering the rest of the building. Also, I do want to say that I think one of the judge's secretaries did get COVID, and her husband is a cop, and he got COVID and is now on life support on an ICU and on a ventilator, fighting for his life. So I don't know how they got COVID, but the wife did work for a judge's JEA secretary, and it's scary. And he is he was a high level, was it a captain in Metro? Who got who first, but he's fighting for his life right now. Okay. Point being, I'm not going to be able to do trials live in person until there's actually a vaccine or they're declared safe to go into the courthouse. I'm not at liberty to say if I have a family member who's high risk, if I have underlying conditions at high risk. All I know is that I am not returning to the courthouse until it's safe. There are some attorneys also that have difficulties coming to do the trial. And if we were to come to the courthouse and wear masks and stay 6 feet apart, you know, we've got plexiglass in the courtroom, it'll be very difficult to see people even with their masks on. So I have no idea if your facial expressions, etc. It was already planned that Goldie was going to stay in Seattle and finish up any kind of rebuttal testimony, but we got a good chunk of her testimony in before COVID hit us. So I don't have an issue with that, and that's nothing for Goldie to be concerned about. Goldie was going to stay on video, but I have to ask Mr. Page and Dad, Alex, you've got two choices. You can stay on the court's calendar until it's safe to go back in the courthouse. If you insist on doing it in person, it could be a long wait. Some judges are setting trials continuing them to next June because of COVID. Or we would finish this trial on Blue Jeans. You don't have to wear masks. I could see your faces on the video and your witnesses and do it all by video. There are downsides. The downside is Goldie and Fred may need to talk during the trial for strategy or whatever. But there are, if you look at the chat box, there are direct messages, so you can Goldie can send a direct message to Fred, and none of us can see what they're talking about. And these chat messages disappear at the end of the hearing when we log off and leave the meeting. So you can use the direct messages function, and the share screen function is to show your digital evidence, your exhibits. I will have the trial exhibit notebooks from both sides with me, and you each should have your hard copies of the notebook, so you can refer to it by tab number, tab letter, and the bait stamp number, and I can absolutely follow along. And if you want a share screen function or play a video or show the actual document on the screen, then it can be posted. Your your desktop will show up, and then you can show your. So you must learn how to use the share screen function. And who is sending me a direct message? Alex.
I'm having a hard time hearing you.
That's your direct message. I am on full-blown audio. Is that better?
A little bit, yes.
Well, I don't know. You've got Apple AirPods in there, so they've worked. I haven't tested my Apple AirPods. You might want to put a hardwired headphone set then into your laptop or your cell phone to get the audio.
Okay.
I'm getting a little bit of... let me see if this looks better. I'm going to mute Mom because she's in her car, and I think that eliminated a little bit of the feedback noise. So we are going to have some bumps in the road. We're doing this trial, but we are all high-tech here, and we can do this efficiently. John, you are top of my list. I was planning on having you guys... I have not returned to the courthouse since May 30th. Okay, I've been doing everything by video. You were my first trial I was going to get going. And then this news of employees and people on critical life support, it's too scary, and I don't want to endanger anybody's health. Mr. Page, I know that you were never opposed to blue jeans, but it was Dad, and I'm not holding it against Alex, but he wanted to come in person. Really, I tried my best, but I'm not putting anybody's health into danger here. And if we did it, we can't do it with masks on. I just can't see you guys in the masks.
Considering the situation and where we're at currently, I completely understand and agree, and I'm good with continuing on Blue Jeans.
I need to hear from you too, Mr. Page.
By the way, I have AirPods in my ears, and I hear you just fine.
Wonderful. Okay, so we know AirPods work. Do you agree, Mr. Page, to finish this trial by blue jeans?
We would prefer to finish the trial in person. The reason being is Mom still has to present her case in chief. That case in chief deals with significant issues regarding Mr. Counsel, including her request for an order to show cause, whether there was fraud incurred in the obtaining of his original child support amount. There are just some issues that I think we need to be in person for.
May I suggest this? Can we not bifurcate the custody issue? Bifurcate, and you can go next year on things that are an emergency. Money issues, whatever the issue you were talking about. But we're talking about the custody of their remaining child. He's 14 now? Gonna go on.
He's 13, Your Honor, and time is the essence with education and schooling. And when I filed the original order, none of this was taking place, and okay. It's definitely an urgency matter to finish this before school starts, because his education and the best interest is in mind.
There is a fix to this. There's a fix. I can do a temporary order. It's not a perfect fix, but I can do any kind of temporary orders. Nevada is going virtual. Mom, I'm going to unmute you. Is Seattle going virtual? I'm pretty sure Seattle's going virtual.
Your Honor, there's, I'm sorry,
okay.
Go ahead.
Yeah, Mom's, okay. I'm going to put that in the chat box. Okay. In-person trial.
There is an option to do in-schooling here in Las Vegas, 5 days a week.
Private school?
At private school, absolutely, considering Gage's grades and his 2 years of downfall in his education, Him doing the education online, I just don't see that being productive at all, nor in his best interest. He's got to be in a classroom. He has got to be in a new environment where his education and is prospering.
Okay.
That's why I would like to finish the trial set on August 5th via Blue Jeans to push the matter along. It is urgent.
Please be. I'm just typing something in the chat box. Okay. So legally speaking, mom has primary physical custody, and she has the school, so we'll stay with her. What dad is asking right now is a temporary change of custody, if there's any basis to do a switch of custody until trial, temporarily. So
yes, Your Honor.
Now, we are in the middle of trial, so you're supposed to present new stuff to me, at least to the judge, whichever judge it will be, in the trial. How his school year ended up in Seattle. Did he fail all his classes? Did he bring them up to A's and B's? That would be new information I would want to know. It would be a subject of a motion, so it's like we can't argue and hear that right now. It would have to be some type of a motion to switch custody until trial, but you would have to pitch it on the school grades and any other change of circumstances, whatever you guys have to argue. Seattle in the news every day, but I don't know how, if mom is away from all that craziness going on downtown Seattle, all the protests. We're not getting a lot of it here in Vegas, Mom, so I just want to make sure you and your sons are safe, obviously, but it's an inquiry that needs to be made that you are able to not go near that area. So if it's not an issue, it's not a problem. Stay away from the protests.
It's not an issue. That's downtown Seattle. Mom lives in Auburn, Washington, which is a totally different world.
GAL needs an update. So when was the last time? Oh, I spelled that wrong. Update.
One moment, Your Honor. Going back to the motion, I wasn't clear on if I could file a motion or not. If I do need to file a motion to show cause, because obviously I'm not an attorney. I don't really know. So if I need to file a motion to cause, and if I need to file a motion on his grades, I will do that today and tomorrow. I was just unclear because trial was just right around the corner.
It's not a motion for an order to show cause because no order's been violated. What we do have is a child who's been doing better in school in mom's care than he ever was doing in Las Vegas. There is no factual dispute as to that. And according to the time the summer vacation started, he had markedly improved from the time when he was in Las Vegas.
Your Honor, in respect to that, Mr. Page is incorrect. His grades are C-minuses, barely C-minuses, just because of my communication with his school in Washington. He didn't even finish or log on to his classwork for an entire month while he was on there. And then including that, I asked his teachers to please give him grace. I explained the situation to him, and he was able to complete a little bit of the missing assignments that he had because of his lack of attendance while school was in class and during the COVID situation. He squeaked by with C-minuses and Ds. In my eyes, in my opinion, those are failing grades. His time is the essence. Gage is losing his childhood. Gage is losing his abilities to prosper, not only just with his education, his athletics, and with the current world situation. It's in his best interest to be in class with his classmates, preparing for high school, and he's never going to make it into Gorman going down this path that he's been going in Seattle for the past 2 years. His grades are failing. He can't even get to class in time or even get to school. So
we're not arguing that today, okay?
I understood. So
file a motion. Now, only thing, timing is everything. So public school, they start August 24th. You have a proposal for private school, and you would pay 100% of the private school. We would need to know. I do know that Las Vegas Day School is going 5 days a week, just because I got friends who've got kids that are going there. And I need to ask the GAL. So you have to file a motion, and for the lawyers that are present here, it sounds like an Arcella. I'm gonna put that Arcella versus Arcella. I don't know if those factors come into play. I don't see why not. We should take a look at that too. So we're looking at the Arcella factors for school choice. Okay. And you need to brief it under Arcella or brief it on best interest of the child for a temporary change of custody because child, and let me give you some heads up about child. There are 2 females running in my department in Department I. If they, whichever wins, it's going to be a female. However, we are getting 4 new family court judges that are coming into domestics. There is no guarantee you will stay a Department I case no matter who wins my department in the election. That means you could be found out and reassigned to another one of the 4 new judges that we're going to create 4 caseloads for them. So you would be reassigned to a new judge if the trial were to occur after January 1st.
Your Honor, with this being my case, and I apologize for the just lack of knowledge. Can we push to just get this finished? Like I said, it's urgently. He's missing opportunities in life. He's missing educational opportunities. He's missing out, and time is the essence. This has been going on quite some time. Unfortunately, due to the situation that the world is in and the economy and everything else, I would highly recommend and ask the court, please. We just need to finish this ASAP.
Okay.
He has no evidence to present. You've given him, I don't know how many days now in which to get this done, and he can't seem to figure out how to get it done. He's provided no evidence that there be any improvement of any kind in Gage's well-being by doing anything on either a temporary or a permanent basis. All we're doing is churning up time and churning up attorney's fees by having to come back to court time and time again while he proves nothing. None of the evidence that he put on is actually relevant. Whether the child plays football at Gorman has nothing to do with his best interest. Him saying whether the child is failing when he gets a C and a D, a C and a D is still not an F. What was an F was the grades that he was getting in Las Vegas, and those were actually Fs.
He did, I'm not going into debate here because this is just a status check, and we can save that for trial.
I don't want to.
However,
Mr.
He couldn't get to class in time.
Can you hear me?
Barely.
Okay, so I don't want to have to hit the mute button because I do have that power. So
okay, absolutely.
All right, I have it. Okay, here comes the chat box. This is my ruling. Court policies. If a person wants in person and no stipulation of blue jeans, it will be deferred to in person whenever it's safe to come back to the courthouse. The temporary orders, can be adjusted anytime. So file a motion. Okay?
Yes, Your Honor.
All right. Now, I have the discretion to do the temporary change of custody. They're based on either a motion ruling, oral argument, exhibits, if briefed on that, or I could also say, okay, now your motion is before me, so let's have a 2-hour evidentiary hearing on the schooling for him because it's critical. And if people really want to present a lot of the evidence, just focusing solely on the schooling and how it impacts on Gage's best interests. So it would have to be a motion. Typically, if you brief it well enough with exhibits, and we have like a long, like an hour-long hearing, I'll say, okay, you got 20 minutes to pitch your case, and then the rebuttal, and then I'll say, okay, well, there's enough here or there's not enough here. Okay, so file a motion.
Your Honor, on that motion, do I need to include some of the evidence that I've already presented in this trial?
He can't be asking for legal advice.
Yeah, speak to an attorney, Dad, about what you want to put in there. The attorneys will know. The attorneys will know. So it's the type of consultation. Now, before I forget, if you have any fear that the judge will have to start your trial all over again, it will not happen that way. I don't expect it that way. We will make sure that a new judge will absolutely get my trial notes. I take trial notes almost verbatim what the witness says on the stand, but I only type what I think is necessary for best interest of the child analysis. So I have got detailed, single-spaced, 10-point font notes. I don't know how many pages there are. 10-point font entries, okay? as to the directs, the cross-examination, etc. So that judge will have the benefit of the notes. They will have the benefit of the accessing the videos to those days of trial if it's going to be in person. And it will be, the trial exhibits will be preserved to finish up the trial. Okay. It's easier said, I know. I cannot speak for the new judge, but I have to entrust the new judges. So, yeah, I mean, it could be experience-wise. I've been doing this 20 years, so, I can jump in the middle of a trial and finish it. Would the new judge be able to do that? They have no choice. They have to do it. The upside is, if you're a brand new judge, you may be, new to it, deer in headlights, but you're definitely going to be super attentive and very diligent when you're first. I've been there. I've been, my first year on the bench. They were like, until you settle in, it's a big learning curve, but you're very, very diligent. So you gotta have a new judge. I'm decommissioned after December 31st by statute. Term ends. Okay, so I'm alerting you. That is my policy. I must get both sides to stipulate. It happened yesterday. Our other case, we were in the middle of trial. They were on my list, and the one of the parties' attorneys said we prefer the in-person, and it is what it is. So COVID has really turned this world upside down, and we're doing our best. There are courts in other states that are literally have been shut down. We've been running. We never shut down since March. We're hearing motions, but the trials are always the biggest, difficulty. And I'm doing my best to use technology to finish it. And I understand people want closure. Maybe somebody's in a hurry more for the decision, but it is what it is, and it falls in that category where if you want in person, it'll be delayed, but I can make any temporary orders, at least for the next 6 months until my term ends. So let's move on to Shelley Cooley, our guardian ad litem. Ms. Cooley, when was the last time you made a contact with Gage? And was it did you get hit by COVID so you never had an in-person? Was it all video?
It was all video because Gage was in Washington. I last had contact with him in November 2019. You just recently issued your order asking for an update. And then we got this hearing scheduled, so I will be initiating contact as soon as we figure out dates going forward.
Okay. We have, so just you heard everything, Ms. Cooley. We're going to have probably a school motion being filed. And if it's filed in the next couple of weeks, we might have a court date in 6 to 8 weeks out. Is 6 to 8 weeks sufficient to get an update for us? Because it's been quite some time.
I believe so. I have some questions. Are you wanting me to address the school choice issues, or?
Gage has a voice on this. Yes.
Okay.
Now, are you doing this pro bono?
I have been, yes.
Okay, wonderful. First of all, thank you for your pro bono service. And second of all, because I don't want to cause too much work, you're fine with me when pro bonos, you can let other pro bono attorneys do that, to give me on any of these supplemental stuff, a verbal, of just taking and give me a verbal and just appear in court and just it's so much easier to say more just talking than have to type it all out.
Agreed. Okay.
Yeah. I'm sorry to put you in any disadvantage. I don't intend to, Mr. Page, but we have a free attorney doing this, so I have to choose between having a report a week ahead of time or just giving the verbal. The verbal is least least amount of work that I would cause.
Cumbersome.
Yeah, cumbersome is the word. Yes, so verbal report approved.
Okay.
So you don't know what Ms. Cooley is going to say on Gage's behalf, but we will certainly hear her at the time of the motion, and we'll get your appearance. Just, go over your notes. I don't need any formal report because it's hours. It takes hours and a lot of blood, sweat, and tears to write these reports. And since you're free, I'm not going to make you do that much work for all that unless the parties want to start paying her. whatever her rate is. I can get a report in, but it's too much work, and she got a lot of work to do as well. So verbal report approved. There will be no written report ahead of time, and she's objective. So just tell me exactly what's on Gage's mind and what's going on with Gage from his perspective. He is in town, Miss Cooley, so I don't know how you'll arrange that with Dad. Dad will make him available because he is local right now.
I gathered that from the hearing we had yesterday.
Well, I don't know if you really, it sometimes makes a difference if you see them in person. If they come to your law office, I don't know if you allow people in your conference room and sit 10 feet away from the conference table. I don't know. I'm just throwing it out there, guys.
The difficult thing with that is that if I meet in person with clients, we're wearing masks. And it's very hard to read expressions and such when everybody has a mask on. But I'll figure it out, Your Honor.
Then video probably because it's hard to see that one. Okay,
Right.
So video is fine, but I just wanted to let you know the boy is local. When's he due to go back, Dad?
I'm sorry?
When?
Mom would know that.
Do you know Goldie offhand?
Yeah, September the 2nd, which is exactly a week before school starts, but I was going to ask for the Saturday before.
Is there any issue with that, Dad? They're going, because she's got to set him up for virtual, right?
He has everything he needs. They did virtual.
Why do you want Saturday? I'm sorry, why do you need Saturday? You taking a vacation or something?
His brother's getting married.
That's a once-in-a-lifetime thing. Is the wedding in Seattle?
No,
Where is it going to be?
Indiana.
Okay. How old is he now? 19? Is he the 19-year-old brother?
No, it's his oldest brother.
How old is he?
It's his stepbrother, Your Honor, and I believe that Saturday we have arrangements.
Brother. Brother.
Just half.
They're gonna do a social distance wedding,
Yes.
and you guys are traveling to Indiana, flying.
The boys are supposed to be in the wedding.
Okay. It's a once in a.
Yeah.
Because we're virtual, Dad. Because we're virtual, I've got a lot of flexibility because he could do his work online. With the virtual, is he mandated to do Zoom meetings with his teacher classes every morning, like from 8:30 to 11:30 or something like that? How does it work?
Yes. Yes, and he has to reside in the school system. He has to be present in the school system.
But if he's hopping out for a wedding or here and there, as long as he has internet, they're not going to check where he's at, right?
Yeah, school starts on the September the 9th, and he has to be present in Washington in his school system at that time.
Virtually?
Yes, virtually. But they're doing checks to make sure that the children are in the school system.
Not sure how that works. Do they do that every single day, like your location?
Yeah, that's what they're going this year because they already started the distant learning in Washington last season, or school.
They're keeping tabs on them kids. Every single kid in the school district is their location sharing.
They've even checked on him during the summer.
Do they?
They can't have.
Yeah. What happened to my chat box function here? Okay. We lost Alex for a second. He's got to jump back online. I just saw that. Might be an internet connection.
That was one of my questions when I ate at school.
I don't want to talk when Alex isn't here. We don't want to talk behind his back, obviously. There's no ex parte allowed. So be patient. This happens with these hearings. We lost them. I don't think it was intentional. He was probably renting a room in the local library again. Trying to call in. Okay. Jeffrey Ann.
Yes?
Oh, I'm sorry. Let me unmute you. I think we need to turn the video off until we can find Alex again. Turn the video off.
Can you
We
see
lost
it,
him.
Judge?
Are we off? Did you stop recording?
I'll stop recording now, Judge.
Thank you, because we lost